Hey, Tony DeWitt here, Missouri Appellate Attorney. I'm retired, and this is not legal advice. Everything I say is simply commenting on the law, and this will be what we're commenting on today. Today we're going to talk about the rather ridiculous testimony by Sarah Boone at her trial. But before we get there, I want to respond to someone who offered a comment that he didn't understand how the judge could find a scintilla of evidence of some kind of threat from Mr. Torres by virtue of him sticking his arm outside the suitcase that he was zipped in and that he wound up suffocating and dying inside of after being bludgeoned with a ball bat. So let me explain, if I can, what's going on, because it's probably not obvious. The way that issues get preserved for appeal is somebody makes an objection. Your Honor, I need to get into this evidence of abuse by Torres because it bears on battered spouse. And the requirement is that there must be some evidence that there was this battering, that there was this effort to, cause harm. And the judge defined the standard as just being a scintilla. Well, there is an absolute requirement that a judge must give a jury instruction where there is evidence to support it. Now, the defense seems to think that him sticking his arm outside of the suitcase is some kind of a threatening gesture, and as a result, there is, there's this scintilla of evidence of threat. What the judge is actually doing is he's taking away an appellate issue because he's going to give them the opportunity to present this evidence and to make this claim that this was some form of battered spouse self-defense. He's going to do that because he has spent the last 4 years listening to Sarah Boone lie about pretty much everything. Now, that's my opinion. It's not a fact. I don't want to present it as a fact. But in my opinion, he's listened to her spout all of these lies, and now at the 11th hour and 59th minute, oops, it wasn't just us playing hide and seek and a sad mistake. No, I was getting back at that rotten guy because, he, for whatever reason, had beaten and bludgeoned me in the past. And indeed, there is evidence that they had words that night because the two roommates said, that they had words. So there is a scintilla of evidence. But juries are not stupid. They are very difficult to fool, and it's going to take more persuasive rhetoric than I think Owens has in him to convince a jury that in that suitcase he was a threat to Sarah Boone. Because that's what he's got to convince them of. He's got to convince that he was an immediate threat, that he was coming out of that suitcase to harm her, to batter her. And the only evidence we have in that regard is Sarah Boone's own statements in that regard. Let's talk for a moment about what we don't have. We don't have any of that on video. We don't have his arm coming up out of the suitcase on video. And the only place we have that is in her testimony. So let's look at a little bit of this testimony, and I'll tell you what I think here.
Sarah Boone, 101077.
And could you spell your name?
SRAHBOONE.
All right, thank you very much. Sir, you may inquire.
Ms. Boone, would you please tell the jury where you were born and raised?
Atlanta, Georgia.
You were born in Atlanta?
We're in Atlanta.
And how long did you stay in Atlanta before you moved here to Florida?
I was 3 years old, 3 or 4.
Okay. And from that time, y'all moved, you and your family, your mother and father, moved to Orlando?
And my grandparents.
Okay.
Okay, it's nice to know that she was born in Atlanta, and, he takes her through at least some of her life story. If this is an attempt to humanize Sarah Boone, you should have started 4 years ago, because right now people are aware of her antics and her problem with the lawyers and all of that. And I don't think anybody is buying into any humanization that's coming as a result of that particular testimony.
Needed more to live.
Yes, to pay the bills and for rent.
So did you and George have some agreement?
We did.
All right, what was the agreement?
The agreement was that if I decided for he and I to live with one another, because it would be under my name, that he would help with the monthly bills and on a regular basis where it wouldn't be something that I would have to argue with him about. It would just be an automatic. Make sure that everything's paid first, and then from there, hopefully have some fun with it.
Now I'm a little confused because I don't understand what the value of that testimony was to Sarah's defense. The idea that they had an agreement with respect to how they would take care of the bills. It may relate in some offhanded way to the arguments that they've had, but it doesn't do anything in terms of advancing the ball on the issue of battered spouse, and this is where they're going to hang their hat. They have to get that information in front of this jury, and I feel like if I were there, I would think I was wasting my time. And I honestly believe that Owens is wasting his time with those sorts of questions. The number 3 rule in trial is don't bore the jury. Give them something to hang on to. And he's not doing that here.
Now, Ms. Boone, let's just, instead of one long speech, let me break you up over the course of the day. So, do you remember the date of February 23rd, 2020?
Yes,
Do you remember getting up?
yes.
All right, just tell the jury about that morning. What y'all did that morning. What you and George spent the night together at the apartment.
Yes, at that point he was living there.
Yes. So y'all slept in the bed together upstairs. February. So you would have gotten up. Y'all would have gotten up that morning, February 23rd of 2020.
Yes.
All right. Tell the jury what happened when y'all got up.
He was already downstairs, and I went downstairs, and he wanted to start the day off by drinking because it was a day off from his job. And I talked him into cleaning and tidying up the house for a sense of accomplishment. So that is what we did for however long that it took. So we did tidy up the house and got everything in order, and it was kind of a reward, I guess, to be able to sit and enjoy ourselves and sit on the backboard.
Okay, I have to admit, this kind of testimony is really sort of driving me crazy. A sense of accomplishment. She wanted to give him a sense of accomplishment by cleaning the house so that they could enjoy their time together. This is the kind of thing that you say to a 4-year-old when you want them to clean their room. It's no wonder that George had rage issues if this was the constant way that, he got treated. Now, I'm not saying that would ever, satisfy the reason to hurt someone or hit someone. There's absolutely no excuse to ever hit a woman. And George, if he did that, well, he has to answer for that now at a higher power. But in this particular instance, this kind of testimony just makes me shake my head. If I were sitting on that jury and I heard that, I'd be going, what? You're trying to give a man a sense of accomplishment by having him, or basically conscripting him into cleaning the house? Don't make me laugh. He doesn't have a sense of accomplishment. He has a sense of being angry at you. Sometimes it amazes me how people just don't think through things, and then they offer testimony like this that is so incredible that a jury is going to have trouble connecting with it, I can assure you.
Point during that time period, did George go to Publix again?
Yes, I thought he was going to be walking to the convenience store, but apparently when he returned, he had gone across the street with my car and my debit card to buy another bottle of wine.
What was your understanding of where he was going?
To the convenience store, walking.
For what?
Cigarettes.
Okay. And you learned obviously that he came back, and you learned that he'd used your vehicle,
Yes,
and he'd used your debit card,
yes,
and he'd brought back a bottle of wine from Publix.
correct.
And you saw the Publix video of that.
Yes.
So he comes back with the other bottle of wine, and did he want you to drink with him?
It was expected, yes.
Yes. And you agreed to consume the wine, the second bottle with him.
Yes.
So over the course of that evening, drinking the wine, what did y'all do time-wise? Watch a movie, music, just kind of tell the jury what you remember. I know it's obviously been a while, but
It was kind of a regular thing where I would always try to come up with entertaining activities for George, and for I bought a puzzle. We started off at one point doing a smaller puzzle, and then we did that very quickly. So then I purchased a larger puzzle, and I believe it was 1,000 pieces. So I thought to get his mind off of things and to focus on something, it would be smart for us to do the puzzle. So for however long that took, we finished the puzzle.
Again, this isn't moving the ball. This isn't getting them to the battered spouse stage. And it continues to infantilize Mr. Torres. It basically says he's, some kind of third grader acting out, and so as a reward, you're going to play a puzzle with him. They have obviously a very difficult relationship from the testimony that we've heard, but this is further testimony that this was a recipe for a disaster from the very beginning, based on the way just these two people are interacting.
I'm talking about just the 2-minute video part that was recorded. Could you just tell the jury what you were feeling, what your feelings were at the time, and then explain that to the jury? You talked about it before. You said he was in that confined space and it was my chance, but do you want to elaborate on that? Or?
Sure. I want you all to know that the majority of the time, am always afraid and always scared.
All right, well, I understand that. Yeah, I understand that. But would it be fair to say that you had some anger at that point?
I did.
Would it be fair to say that you wanted to tell him off to some degree?
I just wanted, yes, for him to have a better understanding, which was the whole point of the videos and documentation prior.
And you could tell that he was uncomfortable.
I'm guessing.
And did you want him to feel some uncomfort?
I did.
Okay. Now, at some point, you turned off the video.
Yes.
And then we saw a second video, which was approximately 11 minutes later. And you've seen that video. It was played to the jury. It was 22 seconds long.
Yes.
And I don't think you speak in that video. You hear George say Sarah one time.
Yes.
Is that fair to say?
Yes.
So between the 2-minute video and the 22-second video is an 11-minute period. Would you tell the jury what happened?
We continued to, I guess, speak to one another, and his tone changed, and I knew the tone, and we ended up, I guess, arguing back and forth with one another, and it was the things that he was saying very much frightened me, and cursing at me and threatening me. And
Did he want you to let him out of the suitcase?
I'm sure so.
Let me see if I understand this. You're guessing that strapped inside this suitcase, he was uncomfortable. You're guessing, or you think, that maybe he wanted out of the suitcase. I mean, that was sort of the whole point of the arm coming out. I mean, let's talk about that. This testimony, I think in fact, I'm almost certain that she just thinks she's killing it here. She's telling her story. This is her big moment. She finally has an audience. She turns to the jury and lets them know, I want you to know I was always afraid. If you're always afraid, you don't stay with someone like that. You find a way to get out. This is a woman who is smart enough and able enough to have an apartment, have some nice things, and her reaction to getting clobbered is to stay there. Her reaction to having somebody threaten her is to zip them in a suitcase. There are elements in this that could have been done in a way that might have somehow sounded like it was self-defense, but at this point in the narrative, they have lost the element of immediacy. They've lost the element of any real means for him to inflict any harm on her. And there is no evidence of any threats other than what she testified to, which very conveniently doesn't show up on video. I mean, we don't know that he wasn't pleading for his life during that 11 minutes, which is far more likely given the fact that he was developing positional hypoxemia. So I have to suspect that most of this narrative here is just made up completely out of whole cloth.
Yes, I bought it for my son.
Is this the bat you used?
Yes.
And you said you poked him with it?
Yes, I kind of pushed, like I held it with the skinny part here and then
So the grip here,
prodded at it. Yes.
you grabbed it with both hands here,
Yes.
and then the barrel of the bat, the big part of the bat is here.
Correct.
And you thrusted it into the different areas of the suitcase?
I started with his hand, and his hand, he was still trying to get out. He was still trying to do that. So I started to push on the suitcase around it, hoping to have his hand retract and go back inside.
You made those injuries.
I did.
We've seen the photographs.
Yes.
We see the bruising. Is that from that bat?
Yes.
Eventually, did his hand go back inside from you doing?
Yes. Finally, he had subsided and retracted his hand.
So in your mind, did you prevent him from attacking you?
Absolutely. Split-second decision.
Now, once he retracted his hand, do you remember zipping it up some? Or what did you do in relation? Because he was upside down, was he not, at that point?
Yes,
At some point, you flipped him back up.
I did.
Tell how that happened.
He wasn't cursing. He wasn't threatening. His hand was inside foremost. There was no more of him trying to break through the suitcase. So I felt safe enough to turn it back over. It wasn't happening anymore.
That line right there, it wasn't happening anymore. That's a line I suspect you are going to hear a lot in the closing argument from the prosecution. It wasn't happening anymore. So, if it's not happening anymore, why not unzip him, let him out of the case? In other words, there is no clear threat to her safety at this point. She just admitted that under oath in front of 12 jurors. And Owens quite effectively got her to admit that. Now, he's going to hang his hat on this idea that, the sense of threat can be pervasive and can occur when other people wouldn't necessarily think they were being threatened. But I don't think that's going to go over very well with a jury in this particular case. I think right now, if she loses this case and winds up being convicted, that right there is going to be one of the pivotal moments in this case. But now let's watch a little bit of the cross-examination, and I'll tell you what I think of the cross-examination.
So you testified earlier that you all had about half of one of these bottles left from the night before, correct?
Yes.
And so, what is our prosecutor doing right here? Well, he's going through this process of elaborately unwrapping these wine bottles and setting them up on the counter because he wants the jury to pay attention to the size of the bottles. Now, he can tell them how many liters is in it. That's not going to make much of a difference. But when he finishes here, what you're going to see is he has accurately demonstrated how much wine was in these bottles.
So would you agree that this is one of the 3 bottles that was purchased between February 22nd and the 2 that were purchased on February 23rd of 2020?
I'm guessing it is like the bottle, yes.
All right, and it's 1.5 liters. Would you agree?
Now, I suspect what he's doing here is to look and see if it says what the weight by volume or the amount of alcohol is in the bottle, but it doesn't actually say that. And so he really isn't doing anything but stalling here a little.
And when you say half, are we talking about to the top of the label was left from the day before?
Oh goodness, no.
All right, a little less, halfway through the label?
It's too right about.
Okay, about halfway through the label. So in addition to halfway through the label, which you began consuming after going to college at about 12:15, correct?
Yeah.
So you all would have began consuming around 12:30. Is it fair to say when you got back?
I can't tell exactly.
Okay. And after finishing what you all had left over from Saturday, the 2 of you consumed 2 1.5 liter bottles, correct?
I'm not sure about the second bottle that he purchased, if it was empty or not at the time.
Well, you did mention that the police would find 2 empty bottles in the top of your trash, correct?
Yes.
And we did all see that in the photographs, correct?
See that
Two.
they empty in the garbage, yes.
All right, and you say you were about 100 pounds at the time? And we all know Mr. Torres was 103 pounds at the time of his death, correct?
That's what he said.
All right, so that's 3 liters of wine between 200 pounds split between 2 people over the course of a day, correct?
Yes.
And you testified today that you were intoxicated at the time that this occurred, the videos between 11 and 11:30 at night, correct?
Yes, at some level, yes.
Now, what does that mean to you? Previously, have you indicated that that means the room is spinning? Do you ever recall saying that?
I do.
So what was your level of intoxication at this point in time when the first video was filmed at 11:12 p.m.?
Do you mean from lack of sleep or alcohol?
From the alcohol.
What was my level?
What were you feeling? Did you have trouble with your balance?
I was more tired than anything.
Did you have trouble with your balance?
Did you notice what he did right there? He went right back to the same question because her answer was unresponsive to his question. Did you have problems with your balance? And this is what she says.
I don't believe so.
So you were able to flip a suitcase over with a 100-pound man in it, right?
I mean, yes, it happened,
Okay. How about your speech? Do you feel like your speech was slurred?
clearly.
How about your inhibitions? Do you feel like you were doing things that you wouldn't do when you were sober?
I wasn't thinking about that.
Well, on reflection, do you feel like this is something you would have done when you were sober?
I didn't know me and George.
I'm just asking you, looking back on this, when he's in the suitcase and you're telling him how you feel, and then you wait 11 minutes and you film another 22 seconds, and then you go upstairs, upon reflection, is that something you would have done and left him in there had you not been drinking?
I don't know. I can't say.
I don't know. I can't say. Either she was a battered spouse or she wasn't. If she was truly a battered spouse and she thought that her life was in jeopardy, she thought that somebody was going to harm her, the answer to that should have been, oh, yes, that's exactly what I would have done because I was afraid of him all the time. But she doesn't see the hook in that question. She doesn't understand that the question he's asking is not really the evidence that he's trying to get in. What he's trying to get in is that her mental state is not that of a battered spouse. It is the mental state of an abusive drunk. And unfortunately for her, she slipped on the Unfortunately for her, she slipped on the banana peel and went right into the trap, and it closed right on her noggin. So this video has already gone a lot longer than I really wanted to do. I would love to have the opportunity to break down the full cross-examination, but I don't think that's necessary. I think the bottom line is the overall tenor of all of this testimony is this is somebody who is telling a tale that she's had 4 years to put together. Now, normally when people talk about traumatic events, like finding somebody that they've lived with for a long time dead in a suitcase down below, they're animated, they're reliving the event, they're caught up in the emotion. They sometimes say things they wish they hadn't, but some of those are explainable. But here, she's sitting back and she's like, well, I don't know. I can't say. There is no change in her affect. It's as if she was talking about swatting a fly on the kitchen countertop. I mean, that's really the tenor of what she's saying. This is no big deal. You know, yeah, I killed the guy. I'm sorry, but that's just the way it is. If I'm on the jury, I'm convicting. Not based so much on the forensic evidence, not based on the cop's testimony, really not based on anything other than Sarah Boone testifying that, yeah, he wasn't causing me any trouble anymore. I could have let him out of the suitcase, but I didn't. And would I do it again if I was not drunk? I don't know. I can't say. Well, you should be able to say if indeed you were actually afraid for your life. So as I've said before, you know, self-defense requires an immediate, credible threat with the means to do, physical harm to somebody, and that is not what we had here. I think the battered spouse defense is going to fail. If I were the judge, I wouldn't give the instruction because I don't think he's met all of the elements of the instruction. But at least he gave him the opportunity to make his record, and an appellate court could always disagree with him. But maybe he will give the instruction and thereby take away this appellate issue. No jury in their right mind is going to acquit this woman. It just is not going to happen. And so we'll see what the jury says. We'll see how the rest of this trial goes. But my money is on a conviction at this point. If you have different views, drop them in the comments down below. Like, share, subscribe, all that stuff. You let me know what you think. I would appreciate it. And then do a kindness for somebody today. Just step out of your comfort zone and help somebody. And, we'll make the world a better place that way. Then, tomorrow, catch me back down here at the beach. We'll talk about something else. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point, and although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. And here are some videos that YouTube thinks you may enjoy.